Good evening, ladies and gentlemen. Thanks for joining us tonight. My name is Brianna Walden with the Charles Koch Institute, and it is my pleasure to welcome you to the latest installment of our author series, The Butcher, the Brewer, and the Baker. Through these events, we seek to highlight the work of individual authors and engage a broad audience in dialogue about the importance of free societies and how they increase well-being for the overwhelming majority of people. I would especially like to thank the Federalist Society and Reason for co-sponsoring tonight's event. As the more than 2,000 alumni of our educational programs can tell you, the Charles Koch Institute welcomes scholarship, debate, and analysis of crucial public policy issues, such as the ones we'll be discussing tonight. As part of the Charles Koch Institute's work to foster productive dialogue among diverse groups on critical topics, we are pleased to welcome Damon Root, author of Overruled, The Long War for Control of the U.S. Supreme Court. Released earlier this month, Overruled traces the long war between judicial activism and judicial restraint from its beginnings in the bloody age of slavery, the Civil War, and Reconstruction, to its central role in today's blockbuster legal battles. Mr. Root tells a story of two competing visions, each one with its own take on what role the government and the courts should play in our society, a fundamental debate that goes to the very heart of our constitutional system. Leading our discussion tonight, we are pleased to welcome Professor Naomi Rao, Associate Professor of Law at George Mason University. Prior to joining the law school in 2006, Professor Rao served all three branches of the federal government, practiced in the London office of Clifford Chance LLP, and clerked for Supreme Court Justice Clarence Thomas. Professor Rao received her JD with high honors from the University of Chicago Law School and her BA from Yale University. Our author, Damon Root, is a senior editor of Reason magazine and Reason.com, where he writes about legal affairs, politics, and history. He was awarded the 2011 R.C. Hoyles Prize for Journalism for his writing on eminent domain abuse in New York. His writing has appeared in the New York Post, New York Daily News, Chicago Sun-Times, Washington Times, WallStreetJournal.com, New York Press, and other publications. Mr. Root has also been featured on the Fox Business Channel and numerous radio stations across the country. Mr. Root currently lives in New York's Hudson Valley and is a graduate of Columbia University. Please join me in welcoming both of our distinguished guests.
Thanks so much, Brianna. It's really a pleasure to be here with Damon to discuss his new book, which sounds a little, which I enjoyed very much, and I certainly recommend all of you read. So to get things started, maybe you could tell us a little bit about how you became interested in this project and why you decided to go ahead with this book.
Sure. Well, first, just thank you all very much for coming tonight. Thanks to the Koch Institute, to the Federalist Society, and to Reason for sponsoring this wonderful event. It's really great to look out and see so many copies of your book in people's hands. Hope some of you read it and enjoy it. So I've been, in college I was a real history nerd, history major, and I took a class called The Constitution in Historical Perspective, which we read 200 years of landmark Supreme Court cases. And that really opened my eyes to the role that the Supreme Court has played. That's the story of American history. That's the great political debates, throughout our history right there at the court. And that sort of began the odyssey that ultimately ended up in this book.
Okay, great. So I think one of the most interesting historical insights in your book is this connection between economic liberty and civil rights, which is often a connection that people no longer really draw or focus on. And so you explain how the historical events surrounding the 14th Amendment included deep connections between the anti-slavery movement, free labor principles, and civil rights. And so I was wondering if you could maybe elaborate on this and discuss that connection between those two ideas, between economic liberty and civil rights, and how they sort of play out in some contemporary debates.
When the 14th Amendment was added to the Constitution in 1868, it came up in the context of the end of the Civil War and the era of Reconstruction. And At the time, the southern states were enforcing these things called the Black Codes, which were deprivations of economic rights for the freed slaves, and also deprivations of civil rights and rights we think of as the part of the Bill of Rights for the abolitionists and groups like that. And so the 14th Amendment was added to the Constitution to protect economic rights from these state abuses. And that's the origins of some of the libertarian legal thinking that I talk about in the book, and that original understanding of the 14th Amendment.
And can you say a little bit about how that maybe applies to some of the current debates that we're having now?
It came up really notably in the gun control context, actually. In 2010, the Supreme Court heard this case called McDonald versus City of Chicago. And the question there was, 2 years earlier, the court had said, the Second Amendment, yes, is an individual right, and it restricts Washington, D.C.'s gun control laws. And so 2 years later, the court was asked, does that individual right apply to the states? And the debate about whether state laws violate civil rights and these fundamental rights is all done through the 14th Amendment. That there's a doctrine called incorporation, and the 14th Amendment is understood to incorporate the Bill of Rights against the states and to be a check on the actions of state governments. So when the Supreme Court is grappling with how to extend the Second Amendment to the states, it's looking into the original meaning of the 14th Amendment. So in addition to talking about the legality of gun control, it's looking into these other meanings of what the 14th Amendment originally did. And so then conservatives, libertarians, and liberals also start talking about, does the 14th Amendment protect economic rights? And we saw a divide on the Supreme Court, most notably between Justice Scalia and Justice Thomas over this question. And essentially, Justice Thomas sides with the libertarians and casts a sole concurrence in that case, and Scalia and the other conservatives, they reject the libertarian argument, or the implications of the libertarian argument that the 14th Amendment would protect economic rights.
Yeah, in your book you talk about the oral argument in that case, in the McDonald case, and as a law professor, I remember Justice Scalia was quite dismissive of the argument that maybe they should reverse the slaughterhouse cases, right? Which sort of read the Privileges or Immunities Clause out of the 14th Amendment. And he said, well, that's an argument only a law professor could make, or only a law professor could like, and was very dismissive of it. And in part, Justice Scalia, as you note, is I think he's not necessarily convinced that that's the wrong legal point, but he's concerned about stare decisis, right? And he said, how can you ask the court to overrule a 140-year-old precedent? So maybe you could talk a little bit about that, right? When should justices overrule their earlier decisions or earlier decisions of the court in sort of advancing a kind of more activist agenda?
Well, Justice Thomas is certainly a member of the court who urges the law to return to the original meaning at the time. And so he's much more aggressive about if there's a bad precedent and it's completely wrong as a matter of first constitutional principles, the court should be more aggressive in validating and wiping away that precedent. And Scalia, he's called himself a faint-hearted originalist on this question. So he's, there's some issues where he's willing to go all the way and grapple with overturning these precedents. And then there's other times, like in the McDonald case, where he said that he had acquiesced in substantive due process. And just to put a little context on that, substantive due process is the doctrine by which the court protects fundamental rights from state abuse. And this is a doctrine that Scalia has railed against for decades and decades. And yet in this gun control case in Chicago, he sided with that. He said, I acquiesce in that doctrine rather than embrace this much more aggressive, admittedly aggressive libertarian vision.
Mm-hmm. I think in part because he's not sure what would be included in that.
I think one of the great debates that I talk about in the book is over, does the Constitution protect unenumerated rights? So it's very clear the Bill of Rights lists free speech, the protection against unreasonable search and seizures, the takings clause. There's enumerated rights, but what about unwritten rights, a right to privacy? The Constitution doesn't say we have a right to privacy, but the Supreme Court has recognized a right to privacy. And Scalia sees these unenumerated rights cases as activism, as liberal activism or libertarian activism, and he sees them as allowing judges to write their own policy preferences into the law. And that's a very commonly held view among legal conservatives. I think Thomas is concerned about that also, but he was willing to to read the constitutional text and say, well, the Constitution does protect unenumerated rights. The Ninth Amendment says that privileges or immunities, due process, those concepts bring in these sort of unwritten protections.
Yeah, and I think he thinks that if the court is going to find unenumerated rights, it makes more sense to find them in the privileges or immunities clause rather than in the so-called substantive due process.
Yeah, he said in his McDonald concurrence, that's what he said. He said, for all the worry about whatever sort of liberal shenanigans the courts would get up to under the privileges and immunities clause, they're already up to those shenanigans under due process. And in fact, here we could actually ground it in the text of the Constitution. Wouldn't that be better?
Right. So, obviously as a constitutional law professor, I'm pretty familiar with these precedents, but one of the things I found interesting in reading your book, which provides a kind of historical narrative of these cases and this dispute over time, is it got me thinking of, can the courts really put a check on, economic regulation that sort of overreaches or impinges on people's economic liberty when those policies are very popular, right? So even in the 1930s, when there was some judicial strength for this position, right? There was the court packing plan, right? And the court packing plan didn't actually go through, but the court obviously changed its course, right? And they bowed to presidential power. And I guess what I'm wondering, thinking about all these cases, is how likely do you think it is that the court can, take a more activist view on economic issues? And doesn't the history sort of show that there are all of these structural and institutional reasons why the court won't do that, and maybe if it did, ultimately wouldn't be effective because maybe undercut by the other political branches?
There's no question that the way the legal precedents and the sort of legal norms are right now, that those libertarians who are arguing for the courts to police economic rights against overreaching majorities, overreaching lawmakers, it's an uphill battle for them. I mean, they're facing decades of precedent. But one of the things, if you look at some of these cases, I do think judges can and should do this. You can look at the work that the Institute for Justice does, for example. They bring these lawsuits, and they find absolutely and there's no shortage of just absolutely outrageous economic regulations out there. In a number of states, you had to have a funeral director's license to sell a casket. Not to be a funeral director, because obviously if you're a funeral director, you're handling human remains, and there's a public health, argument there, so maybe you'd want to license those people. But if you just wanted to sell a casket to someone, you need a funeral director's license. To get the license, it's very expensive. There's hours and hours of study. It's essentially a way for the licensed funeral directors to keep competitors out of the marketplace. And the Institute for Justice has challenged these cases. They bring them before the judge, and they say, listen, there's no conceivable public health justification for these laws. For example, in Louisiana, where you had to have a license to sell a casket, you don't have to be buried in a casket in Louisiana. The remains can be buried in the ground, and also there's the state put no guidelines in terms of the construction of the casket. The top could be open, it could be nailed down, it didn't matter. So what is the public health justification? There's absolutely none there. And so they have brought these sort of cases, and so it's a specific win for an economic right, but it also speaks to this sort of broader principle that judges really can do this. Judges look into the motives, they look into the implications, look into what lawmakers are doing when it comes to a regulation on free speech, when it comes to regulation on privacy. Economic rights are also important, or they should be, and so judges could investigate that further also.
I worked at IJ for a summer, as we were discussing, and I, of course, I very much approve of the work that they do. But I wonder if those cases on economic liberty, do you think it's possible for courts to go beyond the really egregious cases, right? Because all state regulation picks winners and losers, right? They're winners and losers in all of this kind of social welfare and economic regulation. So can they do it when the cases aren't really egregious?
Well, at this point, just getting the egregious laws struck down would be a big win. That would be something. I mean, the way the regime stands now is that there's just this overwhelming deference to regulators on all these questions. So that would be an advancement. I think that you need to have a clear theory of what a legitimate government role is in the economy, and so starting with actual verifiable public health and safety, that would be a good start. And you have so many laws that really don't advance any sort of provable, verifiable public health or safety rationale. So that'd be a place to start. I mean, I do think that this would be a long-term process. This would be something that the courts would grapple with the same way the courts are now grappling with gun control, which was, the Second Amendment wasn't recognized as an individual right by the Supreme Court until 2008. Now we're seeing all of these different tests. What about outside the house? What about concealed carry? What about this kind of licensing? What about the number of bullets in the magazine cartridge? So then there becomes all these debates. How broad is the right? Where does it stop? Where does it start? And I think the courts, they play that role with other rights, and they can play it in this area too.
Do you think it's easier, though, with something like the Second Amendment, which is an enumerated right, than with unenumerated rights?
Well, I think that although economic liberty is unenumerated, we have a lot of very good historical guideposts to look at. Going back to the ratification of the 14th Amendment and those debates, I mean, you had laws in the South that required Black Americans to have these very expensive licenses. This is 1868, 1869. Had to have a $100 license to be a peddler in some small, southern community. I mean, that's a lot of money to anybody at that time. It's a lot of money to a recently freed slave who's just trying to earn a living. Those are laws that are, in fact, trying to keep people from doing things. They're not serving any sort of legitimate purpose. So I do think that there's historical guidance in terms of the kind of policing that the courts should do under the Constitution. So in a sense, it is enumerated because that's built into the idea of privileges or immunities.
And so there are historical precedents that the courts can use.
Well, that's part of the, I think, the text and purposes, that, you look at the text and also the purposes, the historical purposes, the origins of these constitutional provisions, the kind of outrages that they were ratified in response to, that's part of the investigation that the courts would do. That's part of the type of originalism that the courts would do for those provisions.
Yeah. So in your book, you also talk a lot about this, the idea that judicial restraint is something that has been expressed on both sides of the political spectrum, right? You have Justice Holmes, very famously arguing for judicial restraint, and Justice Scalia at times. Today, a political conservative or a legal conservative argues for restraint at times. But the real concern for a lot of these judges and justices who have argued for restraint over the years, right, wherever they fall on the political spectrum, has been a concern about judicial discretion, right? That when judges are kind of leading the way to invalidate regulation, that they will impose their own views, right? So perhaps you could say a little bit about, some of in this back and forth, how do judges who are more activist, as the way you use the term, how can you curb judicial discretion, right? If judges are going to be more activist.
Well, the text of the Constitution would be the first place to look at. And that's really one of the things I write about in the book is the debate that's been happening on the legal right for the past 30 years, where libertarians and conservatives and different versions of conservatives are clashing over these views. And the debate about originalism and returning to the original meaning of these texts is where these discussions have to happen. And so if it's something that can't be grounded in the text, so unenumerated rights can be grounded in the text also, and so you'd start there, and that's got to be the first check on judicial discretion.
Well, but so the unenumerated rights have to also be grounded. So do you think that we take all of the unenumerated rights that the court has recognized?
Oh, in terms of what the court has done up until now? Well, I wouldn't. I think the outcomes of some of those cases can be defended, but not necessarily always the rationales that went into them. So the right of privacy, if you look at that case, Griswold versus Connecticut, 1965, I think that, and in fact, I point to the fact in the book that early libertarian legal theorists defended that case and really differed with conservatives. This is the case where the Supreme Court struck down a Connecticut law that said it was illegal to use birth control. Married couples, it was illegal to buy or obtain birth control devices. And that's a case that Robert Bork and judicial conservatives like that have just denounced. They say that's activism. And libertarians have defended that, and they've defended it on libertarian grounds, not necessarily the court's reasoning, but the outcome, which is that here you have a liberty of contract issue where somebody's trying to buy a harmless product. They're not hurting anyone. Something's going on within the privacy of the home. The government has no business interfering. Just because it's a traditional morals type legislation, that doesn't give the government a blank check to regulate those kind of behaviors.
What do you make of the fact that in your sort of historical account, there are almost no examples of judges or justices who defend both, the privacy line of cases and also the economic liberty line of cases, right? So most judges or justices kind of pick and choose, right? If they're willing to recognize one, they're not usually willing to recognize the other. Does that suggest something about the problems with the judicial discretion?
I think it suggests something about the problems of sort of the traditional left-right, divide that we have. And I would say that libertarian law professors today are the ones defending both,
Right.
and have a pretty consistent argument, I think. And there have been consistent deferential voices who said that's all wrong.
Sure.
And that's increasingly rare. So what you find is old school progressives in the 60s, like Learned Hand, Hugo Black, they were troubled. They were liberals. They were men of the left, and they were troubled by the court's liberal activism, if you want to call it that, in the mid-20th century, and they opposed it. And what you find today on the left is that liberals have embraced this aggressive role for the courts in some areas, but now we're kind of rediscovering the restrained approach when it comes to economic activity, and we saw that in the healthcare case when President Obama sort of on down said, well, the courts should be deferential, they should be hands-off. And so they're definitely trying to have it both ways. And I think conservatives today are trying to have it both, to the extent that they're pro-deference in some of these realms. They're trying to sort of have it both ways also.
So do you feel hopeful that you can get judges who on the bench who are libertarian law professors?
No. I wouldn't say I was optimistic about that. I think Janice Rogers Brown is a federal judge here in D.C. who has been sort of rumored to be on Supreme Court shortlists, and I think that she has defended some of these libertarian economic rights cases, and so she would be probably about as close. And I think Justice Thomas...
Do you know how hard it was to get her confirmed?
Yes, I know you know. And Justice Thomas, I think, is sympathetic to these libertarian views in some of these economic cases also.
So you think it's possible?
It's possible. I think this is one of the things I try to show in the book, is this is a war of ideas that's been going on for a long time, and it's very long term. And just in terms of the libertarians moving the conservative legal movement more, I think, in their direction on some of these issues, that's been going on for the last 30 years. So it's not an overnight sort of process. The law does move slowly. And then in terms of seeding the courts with these type of judges, having people go through law school with these ideas, and then ultimately becoming confirmable as judges. I mean, that's a long-term process.
I was wondering, do you think that having courts that are more activist, or again in the way that you talk about it, do you think that's consistent with the original meaning or original understanding of the Constitution? Like, do you think there are examples from the beginning that we can point to that give us that?
Well, in the Federalist Papers, you've got Alexander Hamilton coming out strongly for an independent judiciary. You've got James Madison writing at the time that the court should be an impenetrable bulwark, he called it, against assumptions by the legislative and executive branches. So I think that there is a original understanding at the time of the Constitution's ratified that the courts can and should be a check on the other branches of government.
Right, but how far does it go?
Well, that's always the question. How far does it go? It certainly goes a lot farther than it's where it stands now in these matters.
Maybe you can say, another thing I'm wondering, I guess to the point of could you get more libertarian law professors on the courts? I wonder if, and this goes back to one of my earlier questions too, which is, if these ideas are consistently losing in the political realm, right? Government continues to grow, right? It's very hard to sort of stem the tide of the regulatory state, and we may all agree that this is appalling, right? But if that's sort of the way the political realm is going, is there much hope that the courts can stop it in any meaningful way, right? Maybe around the edges, but in any important way?
I mean, I'm not sure that I'm an optimist by nature, so I don't know how positive I'd be about that. I think the courts are an area where, the courts are supposed to be a non-democratic or even an anti-democratic branch of government. They're certainly the least democratic branch, obviously, and the life tenure and the nature of the court's role is to act as a check on these popular impulses. And sometimes that's popular, sometimes that's not. I mean, I do think that's a role they should play. Will they? I mean, I'm not gonna, I might not lose I might not bet the farm on it, but.
Right. Yeah, I just see, since I've been, a law student, there was the whole Rehnquist kind of revolution with Lopez and Morrison, right? So they're able to invalidate things like the Guns Free School Zone Act or, parts of the Violence Against Women Act, which are really kind of grandstanding statutes which are largely covered by other state laws or something like that. And so they're able to invalidate those as exceeding the commerce power. But then when it comes to something important, like the Controlled Substances Act and RAISH, and they say, well, we can't even invalidate the application of that to a few marijuana plants, or we get the Affordable Care Act, well, we're not going to really interfere in those areas, right? So there seems like they're saying, well, we can draw a line, but they just won't, not when it's anything really important.
The New Deal legal settlement, that you referenced there is something that's not going away anytime soon. So the kind of role that the courts can play, and that the libertarian law professors and activists that I write about in the book, I mean, I think in their heart of hearts they'd like to see a lot of that overturned. They know that's not going to happen anytime soon, but they think it's important to, even if it's just at the margins, to change the status quo somewhat. And I do think they've had some success in terms of that. I mean, Lopez and Morris, in those cases, that's the first time the government loses on a commerce clause. Lopez is 1995. I mean, that's the first commerce clause loss for the federal government since, 1942, in the Wickard case. So that's something. It's not nothing, and it is there as a precedent. But as you say, it didn't win the day in the healthcare case either.
I just remember being a law student, never even thought, oh, this is like going to be some big revolution, but.
People talked about it at the time, the
right,
federalism revolution,
right?
and
There's a
it didn't
big
quite
revolution,
play
but
out.
whenever it came to anything really important, the courts.
Yeah, well, we can thank our friends Justice Scalia and Kennedy for stalling that revolution in the medical marijuana case. They sided with government
There may
power.
have been some buyer's remorse in the later case.
Yes, I
in
think
the
so.
Affordable Care Act case.
I think that's right.
Maybe. So I had a question too about your title. Right? You call it the long war for control over over the Supreme Court, and the examples. I guess I don't mean to be overly skeptical. I should probably be less skeptical because I am sympathetic to your project. But it seems in a lot of ways it's a kind of unilateral fight, right? Like many ways the proponents of judicial restraint have overwhelmingly won or captured. I think both in the academy and on the courts, they have prevailed to a large extent. So, do you think it's possible to still fight the war?
Well, they are certainly on the winning side right now in terms of the economic rights.
Haven't they always been on the winning side? I guess that's what I wonder. Like, has there really been any large stretch of time when they haven't been on the winning side?
Well, during late 19th and early 20th centuries, there were a number of victories for these economic rights. But the point I wanted to make actually was that this book is not just about those rights too. Yeah. So the right to privacy and gay marriage, gay rights. These are also legal causes that the libertarians have championed, and you can look at the court's reasoning in those cases, and you can trace it back to these libertarian conservative precedents of the progressive and New Deal eras. And that's something that I think that the proponents of this libertarian view can also point to as success. I mean, they've had success bringing liberals over to their view on some of those issues.
So maybe now we should open it up to some questions. What do you think?
That'd be great.
Unless there's some other things. Any questions? I know there's some.
I think there are going to be microphones going around, so if you'll just wait for one to come to you.
I think there was a hand maybe over here. Yeah. Oh, sorry. There's some microphone.
Back in the 1930s, if the court had continued striking down various New Deal laws, and start with, say, the National Labor Relations Act, wouldn't ultimately what would have happened been the ratification of a constitutional amendment authorizing not only everything that the New Deal was doing, but everything else that libertarians are opposed to because people just didn't agree with what the court was doing and wanted some form of regulation. So one way or another, whether the court surrendered or the Constitution got amended, which might have been from a libertarian point of view, a much worse long-term outcome, wouldn't we be in exactly the same place, give or take a couple of words in the Constitution?
Well, I think it's true that the New Deal was very popular at the time, and it may be the case that there may have been enough popular will to sustain a constitutional amendment to support some of what was done. But I'm not sure, that sort of historical what if, we'd be in the same place we are now. What happened, yeah, I'm not sure. I mean, that may be the case, that there would have been enough force to get the Constitution amended. I think in some ways that would have been a better outcome because at least there would be this constitutional provision to then follow and then the democratic process is followed rather than some of these decisions which are less than savory in some of their legal foundations. But.
Hi, I'm not a lawyer and I haven't read the book yet, but I get the sense.
But you should.
Yes, I will. Now that I gather that the kind of main conflict you're talking about, right, it's between judicial restraint and judicial activism, and it seems to me that actually is not so much the most salient conflict, right? There's this right-left divide between living constitutionalism and originalism, and then there's the intra-right divide between originalists about what the actual text and history of the Constitution means. So it seems to me that it's not really about conservatives who always want to be restrained and libertarians who want an active court, but it's actually about, what does the text and history of the Ninth Amendment mean? What is the text and history of the Privileges or Immunities Clause? So why is it that you're framing it in terms of restraint versus activism, as opposed to a debate just over what these texts actually are properly understood to have originally meant?
Yeah, no, that's a good question. The debate over restraint and activism has been around for a century and a half, and it's not going away. And the language of that debate crops up continuously. So when John Roberts upheld the Affordable Care Act in 2012, he cited Justice Oliver Wendell Holmes, who is as I sort of call him in the book, he's the first great advocate of judicial deference. And he alluded to one of Holmes's famous statements where Holmes said, if my fellow citizens want to go to hell, I will help them. That's my job. And that was his sort of vision of his role as a judge. And in the Obamacare case, John Roberts said, it is not our job to protect the people from the consequences of their political choices. So whether we like it or not, this language of deference is there, and it infuses progressive, conservative, legal thought. And so I don't think that that debate about that language is going away. I think the point that you were making, though, in terms of, isn't the better debate about the meaning of the Constitution? That's the debate that conservatives and libertarians are having. That's been the debate on the right for the last 30 years. And I agree that that's a very fruitful debate to have, and that grounds us in the Constitution. I mean, obviously, by definition of pointing to the text, but it grounds us to something we can point to. And one of the things we've seen in the last few years is that liberal groups have sort of started to embrace originalism, progressive originalism. They call it new textualism. And you can actually, liberals can point to constitutional provisions that make strong evidence for some of their causes too. So in fact, they're sort of following the conservatives and libertarians having this argument. And one other thing about the Ninth Amendment I would say is Robert Bork famously referred to that as an ink blot. He said, well, it's an ink blot. We can't know what it means. We don't know what it means. Justice Scalia has made kind of similar arguments about the Privileges or Immunities Clause, that it's not entirely clear. Bork had said that about privileges or immunities. So you do have libertarians who are in fact pushing this much more aggressive role for the courts. They've also been pushing the conservatives to take some of these textual provisions more seriously.
If I could also just add a point to that, which is, I agree with Damon that, there are obviously a lot of important legal issues that people debate about the meaning of the Constitution. But behind so many of those debates is really the question of who gets to decide, right? I mean, the questions about federalism, the questions about executive power, they're always also a question about, should the court be deciding this question at all? And I think your book rightly kind of focuses on the development of that conflict, right? Is the court the right place to be deciding these issues?
Yeah. And
even if we could agree on what the outcome should be or what the principle is, are we the ones who should be making that call?
And also, just one more sort of follow-up answer to that is that my book is really telling the story and giving the history of this debate that's been going on for a century and a half. And I think this debate you have to understand it, to understand American history, to understand legal history, to understand what the court's doing now and will do. And I'm not really making the case for one point of view or another. I have some sympathies and some allegiances, but I'm trying to just really tell this story because I think that this debate is it's with us. It's going to be there. So as much as a lot of people might not like to hear some of these arguments of one side or the other, I mean they're sticking around.
Jason Miller. I'm a law student here in DC at Catholic University, and I had a question related to the Ninth Amendment unenumerated rights. If we say that you've got all these unenumerated rights through Ninth Amendment privileges and immunities, how do we avoid allowing judges to simply put their policy preferences into place, whether it's through libertarian judicial activism, liberal judicial activism, social conservative judicial activism? How do we avoid that? Where is there a limit at that point?
Right. Well, that is certainly the question. That's the question that liberals were asking during the progressive and New Deal era. It's the question that conservatives are asking now. Liberals are asking it again now in terms of economic rights once again as these debates have come back up. There are great textual markers for the Ninth Amendment if you do original meaning type historical research. Randy Barnett, law professor here in DC, has written quite extensively on this. And so you would begin there. I can't give you in a short amount of time a sort of definitive answer. And it's also, you couldn't possibly list every right that you have. Do we have a right to eat ice cream? Do we have a right to wear a hat? All these sorts of things. None of those are enumerated. When the Constitution was being debated and the Bill of Rights was being debated, the Federalists, the party of Alexander Hamilton, the party of the Constitution, for the Constitution, they did not want to add the Bill of Rights because their concern was if you delineate, if you say we have free speech, we have gun rights, these sorts of things, if you list those, then people will say, well, then that's all you have. Those 8 ones are all you have and that's it. And James Madison, who is the architect of the Constitution and who is the architect of the Bill of Rights, he said, well, that's a very good argument. And I think that I have the solution to it. He said, that's the most persuasive argument against adding the Bill of Rights that I've heard. And the answer, the solution is the Ninth Amendment, which is that you make it clear that this list is not definitive. And so you begin with the sort of rights that the Bill of Rights protects. So one way to think about it is positive versus negative liberties or negative rights. And so you go from there. But there is historical evidence to sustain the idea of unenumerated rights and many of the ones that the courts have protected.
Mike Sarn, and I'm just an interested citizen with some background in law. Other people who've treated this subject have used terms like strict construction and hierarchy of laws, that all laws are not created equal and all sentences are not created equal, and that the Constitution really tells what rights really go to the government, and anything that's not given to the government should be owned by the citizens, so that way you don't have to enumerate everything. Those concepts seem to be, have you left those out of your book from a viewpoint that you're implicitly talking about them and those concepts are not for the layman, or are they valid concepts that you subscribe to?
Well, those are certainly valid concepts. I mean, I think one of the things maybe you allude to is the idea that of enumerated powers, that the government can only exercise those powers that are granted to it in the Constitution. And so the debate about the Commerce Clause and the meaning of the Commerce Clause turns on that question and the necessary proper clause and these sorts of things. So if the government is acting, is it acting on a power that the Constitution grants to it, or is it in fact going beyond that and into uncharted territories and essentially seizing power? So those structural questions and debates about the structure of the government certainly feed into this question. And as Justice Kennedy loves to say, federalism itself is a way of protecting liberty. It's not just protecting states' rights, but it's a security for liberty. So those are absolutely valid. If I understand you correctly, those are valid questions. And I hope my book addresses them. I believe it does.
You don't have strict construction as an index item, for example. Is that
Well, so
enumerated implicitly?
Strict construction is a turn of phrase that's fallen out of favor largely and I think originalism has replaced it as at the time that strict construction was used, it was associated with the political right in the mid-20th century. some of the connotations of it are still there, but I think conservatives have migrated largely to originalism, or they're still in a sort of a judicial deference kind of camp. And so rather than say the Constitution should be strictly constructed, they talk about the original meaning of the Constitution. But in terms of, my book talks about the debates over abortion, over Brown versus Board of Education, all those cases, and so those questions are there. But I'm sorry, it's not an index item.
Blame the publisher.
That's right.
Edward Roeder from Sunshine Press. How do you think members of the Senate Judiciary Committee and the Senate as a whole should differentiate among nominees in terms of how they come down on judicial deference and judicial restraint and strict constructionism? Do you think it's appropriate for them to apply their political biases, or inappropriate? Do you think it's appropriate for them to strive for some sort of balance on the court or not?
We were talking about the confirmation process a little bit before we got started. I think that the Senate can try to get as many straight answers out of nominees as they want and will be unsuccessful. That our Supreme Court nominees these days are very good at not answering substantive questions about their legal philosophies. I think legal philosophy is a great area, since nominees aren't going to say, well, I would overturn Roe v. Wade, or this is my view on abortion, or something like that. By asking them about legal philosophy, you can maybe actually get them into the meat of some of these constitutional debates, because everybody wants to know what these people are going to do when they're on the court. But we saw with Roberts and Kagan especially, they were very savvy at giving very diplomatic answers, let's say. And so I think that's sort of where we're at with the confirmation process. That's the kind of answers we'll give.
I also think, if you think about the Senate's incentives, right, they want to have people, judges who are going to be deferential to their legislation, right? So if you look and you read the hearing transcripts for any of the recent nominees, they all sound almost exactly the same. You know that they're going to have very different judicial philosophies, but they all say that they will, be deferential, that they will, call them like they see them, that they're not interested in, that they want to give appropriate deference to the political branches. So as Damon says, you may not learn very much from that.
Yeah, and that's a shame. I think that's a real shame that we don't get more substantive discussion during those moments, because the whole country's watching. It's a time to really have a sort of a national debate about these legal questions that shape everybody's lives. But. Mm-hmm.
Thank you. My question is about the 14th Amendment, and the fifth section very clearly gives Congress the power. And yet that doesn't seem to be a discussion around these issues. On the Voting Rights Act, conservatives, when it was re-upped, conservatives said, oh, you should strike down those, what's the term in the certain jurisdictions in some of the southern states?
Pre-clearance.
Pre-clearance, strike that down. Well, but Congress passed a law, and Congress has the power. On the gay marriage issue, Congress passed a law. California had a law, and yet the court overrode both California and the Congress. And where do we get this idea that that whole section that gives Congress the power to kind of define and legislate the 14th Amendment seems to have disappeared?
Well, Congress exercises quite a bit of power under the 14th Amendment, as you say, in voting rights and some related issues. But Section 1 of the 14th Amendment also says no state shall, and then it's abridged, the privileges, immunities, due process, equal protection. It's absolutely correct that the ratifiers, the framers and ratifiers of the 14th Amendment, the Republicans of the 39th Congress, they wanted Congress to play an active role in protecting civil rights throughout the South and throughout the country. And in fact, the Civil Rights Act of 1866, which was passed over Andrew Johnson's veto the first time, constitutionalizing that law was one of the purposes of the 14th Amendment. So of course, Congress can and should act when it has the appropriate power to do so. But the 14th Amendment places this check on the state governments. And then the Supreme Court also is charged with interpreting the Constitution, seeing if the actions of all these branches of governments conform with it.
Thank you. We're supposed to have a government of checks and balances, but it seems to me there's not really any check on the Supreme Court. it's taken upon itself this right to issue constitutional opinions and overturn laws based on, just opinion that the laws are contrary to the Constitution. Would you favor a constitutional amendment that would allow the Congress to basically override a decision of the Supreme Court? Or perhaps would you favor the Congress simply taking upon itself the right to issue constitutional interpretations that override a decision of the Supreme Court? So basically, the Congress would say Marbury versus Madison that's the opinion of the Supreme Court, but why is the Supreme Court's view of what's constitutional better than the view of the U.S. Congress? So basically, would you favor some type of check on the Supreme Court?
I would not favor giving Congress the power to override a veto of Supreme Court decisions. Congress can respond to what the Supreme Court has done and overrule essentially court's decisions in some areas. We saw that with the Lilly Ledbetter case. So there is a check that exists that way. Teddy Roosevelt, the bombastic, Rough Rider, progressive era politician, he favored the recall of judicial decisions and judges, and his thinking seeded Franklin Roosevelt's approach to the court that culminated in the court packing plan. And I think that whether you like what the Supreme Court has done or not, I think the court's supposed to be an anti-democratic branch of government. And so I think that the Democratic branches have other ways to check the courts, the appointment process, which goes through the political branches, the fact that the court does have to persuade the executive to carry out its rulings in some cases. So I'm not in favor of some of those proposals you would suggest.
Yeah, I want to know your role in eminent domain in New York.
Oh, the eminent domain. So I wrote about eminent domain is the government's power in the Fifth Amendment, the takings clause. It says you can take private property for a public use, and that's traditionally understood, or was for some time, to be a road or a bridge, something the public uses. The Supreme Court, in a series of cases which I write about in the book, started to construe that power very broadly and defer to local economic judgments. That included the Kelo case in 2005, where the Supreme Court said it was all right for this local government to take private property from one person, give it to a private developer, because this new real estate scheme would broaden the tax base, and that was suddenly counted as a public purpose. So in New York, the state officials, they took a bunch of people's homes to build a basketball arena, and this was justified under this Kelo decision and was upheld by the state's highest court. In New York, it's the Court of Appeals, is the name of the state's highest court. And they said that we have to defer to the state agency's power to do so. And so I reported on that case. I happened to live a few blocks away in Brooklyn at the time from where this is the Barclays Center, for those of you who go through New York, where the Nets play. It was a really shady deal, just sort of across the board. The developer was the guy who was working cahoots with the state agency that had this eminent domain power. He was the developer. He was also a part owner of the Nets. It was a nasty one. But and that's also one of these issues that, like I said, I write about in the book. This battle over eminent domain and should the courts be more active in policing the branches of government that are taking private property for these questionable uses?
Yeah, you see them infringing on battlefields, things like that.
Yeah.
Commercial developers.
Mm-hmm.
This will be our final question. We invite everyone to stay afterwards for our reception.
Thank you. I look forward to reading your book. My name is Diana Simpson. I'm an attorney at the Institute for Justice. You guys have used the phrases judicial activism and judicial restraint a lot this evening. And I was wondering how you define those phrases consistently, because it seems to me the question often turns into whose ox is being gored. And I'm just curious as
Sure.
to how you define it.
Yes, I know you guys prefer judicial engagement at IJ. I'm using the term...
It's better marketing.
I'm using the term descriptively, and it's also a term that libertarians have used themselves repeatedly over the years. Clint Bollock, one of the founders of the Institute for Justice, has written a book with, I believe the subtitle was, the case for an activist judiciary, something like that. Richard Epstein has used the phrase in a favorable light for judicial activism. The Cato Institute published a book in the mid-'80s which made a case for principled judicial activism. So libertarian legal activists and lawyers and scholars have used that term in a way to shake up the conservatives who spent many decades under the influence of Robert Bork and the judge and then Justice Scalia making very strong arguments for judicial deference. I think they sort of use that to shake things up a little bit. But I do agree that the term can be difficult because it's used just to describe a decision you don't like. And that's typically how people sort of tend to throw it around. And I'm using it somewhat consistently, and I'm contrasting it with judicial deference, which is the idea that the courts are the least democratic branch of government, and so they owe this great deference and respect to the will of the majority as expressed through the elected branches. And activism is the courts striking down the will of the majority when called upon to do so. But it's a controversial term, and but at the same time, it's as part of the story that I'm telling. It is in fact these people who are pushing these ideas have used the term themselves. So I mostly use it quoting them rather than making some sort of argument for it. So I guess that was the final question.
I think that's the final question, so thank you.
Thank you all very much.
Great, that was fun.